The next claim we want to address is the claim that we're hearing repeated over and over again. This is probably the most common claim you'll hear running into this, that we need this amendment because women are dying and bleeding out on gurneys in other states in the South, in states with abortion laws, in states without abortion laws, that women are going to bleed out and die on gurneys if we do not pass this amendment. And it's important to know, not only for the sake of defeating this amendment, but for if you are a woman in a medical emergency, for your protection, that there are no laws that prevent women from getting emergency medical care. You need to know that. That is a health and safety issue. There are no laws that prevent emergency medical care, and women are not bleeding out on gurneys because of abortion laws. So let's dive into this claim.
Yeah, so when we hear this claim, pro-lifers often reasonably become very concerned when we see the media narrative. You can see headlines pretty frequently of a woman who has some sort of adverse medical condition that experiences how the media describes it as either a delay or denial of care as a result of these abortion laws. And I know for myself and many other pro-lifers who deeply care about women's health and the protection of the women that we care about, that we hear that and we go, whoa, what did we do wrong when we wrote these laws? But then you dive into the stories and we find out that so far it has not been the case that it is the fault of these abortion laws. So you can go to the next slide. We don't have time in this series to go into every single case of claimed medical neglect or denial of care as a result of pregnancy, but I'm sure that you've heard of some of the names, and any that you are confused or concerned about, I invite you to just go on Secular Pro-Life's website, type in their name on our search feature. We've done deep dives into most of these cases. If we don't have it, Live Action has covered most of them as well. And thus far, we have not found a single case where a woman died or even was denied care and had some sort of adverse reaction because of these abortion laws in a medical emergency. And so we have seen, though, women who, like has happened prior to the Dobbs decision, have gone to the doctors and have faced medical malpractice in the course of seeking treatment for either some sort of pre-existing medical condition during their pregnancy that is not treated. There is a reality that in many places there are maternity care deserts. There are situations where women do not have access to high quality medical care, and that's a problem in it of itself, and it's something that we can find common ground with when we talk to pro-choice people, but we do not have to cede the ground that women are dying as a result of these pro-life laws. There have been no cases where the pro-life law is at fault, and in fact, in most of these cases, it's the fault of the doctors who are just not giving them care. Sometimes people cite that, well, maybe they weren't offered an abortion that might have helped their health or saved their life because of these laws. But there's no case that it seems true that that is the case at all. And I invite you to look into the individual cases on their own. But when we talk about this, it's important to say that if that did happen, if someone was denied emergency care, if a woman is in an adverse medical situation and there needs to be an intervention that could potentially end the life of her unborn child, if she was denied care because of a pro-life law, that would be bad. It would be bad if our laws were written in a way that women were dying as a result of this. The good news is, though, that they're not. So we can look at the current Virginia law where we see that if you are in a genuine medical emergency, you can receive an abortion. So we've talked in other slides about how in Virginia currently there are safeguards to prevent against elective abortions for when it comes to later in pregnancy, that you need certain doctors to sign off on it. You need to say it's for a medical emergency or for a medical reason. When it comes to a medical emergency, they can treat you under current Virginia law. This is also the case in every state, whether they're pro-life or pro-choice. It's a federal requirement that you need to treat a woman in an emergency situation. And as pro-lifers, we can say that's good. There's some debate in the pro-life community about whether or not abortion is ever medically necessary. And truthfully, that comes down to issues of definitions of abortion, which we can get into. And we've put out at Secular Pro-Life content about that and about whether that's useful framing or one way or the other. But what's important to know is that there are cases in which it is necessary to intervene in a pregnancy. The classic case is an ectopic pregnancy, where if you do not intervene, both the woman and the child will die. And when you intervene, because the child is pre-viable at that stage, they will not survive. And so some medical professionals call that an abortion. Some don't. They say it's an intervention. But the point is that sometimes it is necessary to intervene and that it is legal. And post-Dobbs, there have been no prosecutions of a single medical provider, any doctor, any nurse, for providing emergency health care. It is happening every day in pro-life states where women are going through things like miscarriages that are incomplete, and so the child has actually died within the womb, but has not been expelled naturally by their body, and women can go in and get DNCs. There are claims that they can't, that women go in and they are denied DNCs until they become septic. In any case that could happen in, that is a misreading and a misuse of the law. And so we want to be clear about what our laws are, because like how Thomas said, people do have an incorrect impression that you can't get care in an emergency, and that's not true. So all of that leads to a culture where we are concerned as community members that it's possible that we could get in trouble, we'll be prosecuted if we go seek care in an emergency. That's not true. We've spoken about already. You will not be prosecuted if you are seeking an abortion, whether it's elective or not. And certainly in the case of a medical emergency, there are no repercussions. However, the pro-abortion lobby and media have put out this narrative, which frankly is dangerous to our community to hear over and over again. And unfortunately, people take it seriously, and they both sometimes can lead to being afraid to seek medical care. It leads them to think that they need to vote on things that will just legalize, decriminalize abortion through all 9 months because of the remote possibility of a denial of care based on a pro-life law. But the reality is that is not a threat to these pro-life laws.
It's also important to note that in many of these cases of medical malpractice, the medical malpractice also comes from the abortion industry. Because if you go to websites that are selling abortion pills, they tell women on these websites, especially on like landcpills.com, that explicitly says, if you experience adverse effects from using the abortion pill and you go to the emergency room, do not tell the doctors that you have taken the abortion pill. Well, that's concerning, because if the doctors do not know the set of facts that led to you ending up in the emergency room, they're not going to be able to provide you with appropriate care and appropriate treatment. And you can talk to numerous medical professionals. Dr. Sheila Fury, who's with the Virginia Medical Freedom Alliance, recently put out some videos and content discussing if you go to the emergency room and you explaining the difference between going to the emergency room for a failed abortion pill and for a miscarriage or for a different medical emergency. If the doctors do not know the circumstances that led to you coming to the emergency room, they cannot treat you appropriately. So it's important to know as well that a lot of this medical malpractice originates from the abortion industry, instructing women explicitly not to tell the truth about how they ended up in a medically dangerous situation. And again, there's no need for those women to lie or to obscure the truth, because under every law, specifically in Virginia, but in every state, it is legal for women to receive a medical intervention in a pregnancy if she's in a medical emergency. It is illegal, and especially in Virginia. So voting for this amendment is not about protecting access to women's medical necessity. It's not about protecting access to care in medical emergencies, because that's already enshrined in Virginia law.
I will finally say, though, that when we talk about this, we need to, as always, when we talk about abortion, lead with compassion, because, again, this is something that is common ground. No one wants women dying on gurneys. And so it's frustrating for me when I look into these cases, and I know if I've studied what exactly happened to each of these women, and it's not a result of an abortion law if they had some sort of adverse situation, or even if they lost their lives. But when we're speaking about this, we should know that we should be able to counter it on a case-by-case basis. But when we're actually engaging with people, we need to lead with affirming their motivations, affirming their concerns, that they care about women's lives, they care about women's health, and that's totally valid, and that we're on their side with that. So what are our takeaways?
So our takeaways we have already: Virginia law already allows abortions, even if, especially if it's medical necessity. So that means if the woman's life is in danger, you can receive an abortion throughout all 3 trimesters. We also know that the medical malpractice that happens in all states is unrelated to abortion access. And actually, a lot of the stories that we have heard are more because the doctors and the providers, like Thomas said, didn't know the situation, or they didn't actually understand their own laws about what they had to do in order to provide the care that they needed to the patient. And as mentioned earlier, as Herb said, some of these issues that we're seeing some of these women facing, it's because of more of how they're treated in the healthcare system, due to whether it's just healthcare deserts, unrelated to if they were able to get an abortion or not. And that is something that the pro-life movement should be addressing about maternal mortality. That can be discussed later. But that is something that we should be also enforcing and encouraging as well with our stance. And then lastly, legislators are pushing these fear-based tactics about women dying. We know that in the legislative session in this year in the Senate and even last year, a lot of the senators and the delegates just kept saying, women are dying, we need to do something about this. And as you can see that we've consistently said throughout this entire presentation, is that women have had access, at least in Virginia, to abortion through all trimesters, the pregnancy. We've not been, restricting abortion access, especially in Virginia since Dobbs. We've had an additional at least 6 clinics open in our state. So Virginia has become a great abortion destination, unfortunately. So a lot of women have been able to get abortions even from other states. And so we know that this is just a misconception that they're trying to prove in order to pass this amendment, especially in November.